Okay, good morning. Welcome to another session of Zoom oral argument with the 5th DCA. I am Judge Lambert. I will be presiding this morning. With me on the panel are Judges Cohen and Sasso. We have one case this morning, case 20-2462, Talmadge versus Connor. Each side, you'll see on the clock, I've put 25 instead of 20 minutes since there's a cross appeal. So each side gets 25 minutes. What we'll do is just appellant, then appellee, then appellant. I think, appellee, so do your response to the main appeal and do your argument on the cross appeal during your 25 minutes or as much of that time as you want to use. We are being Zoom, it's on YouTube, so please keep that in mind when you make your comments to the court. And also, if you have any type of electronic devices, please put those either in the off or silent mode so it doesn't go off and disturb either the court or your opposing counsel. That being said, looks like everybody's here today. So Ms. Hargrove, whenever you're ready to go, this is Talmadge versus Connor. It's our only case this morning for oral argument. All right, go ahead and proceed.
May it please the court, Your Honor, Laura Hargrove representing Ms. Talmadge. Your Honor,
it's a little, I can't quite hear you very well.
Can you hear me better?
A little bit.
See if I can get my microphone. Can you hear that better?
Yeah, that's fine.
You got me?
I do.
Okay. Your Honor, the anti-SLAPP statute was enacted to shield people engaged in their constitutional right to free speech from the chilling effects of defending lawsuits that are without merit, primarily because the person exercised those rights. Here, Your Honor, Ms. Talmadge wrote an opinion letter that was published, and in that opinion letter, she cited two articles in reference to where she obtained her information. Therefore, all of her opinion was given references. Your Honor, this is a pure opinion. Ms. Talmadge was speaking on a public issue, and that is exactly what the anti-SLAPP statute is for, is to protect people speaking on public issues from being engaged in lawsuits such as this. And Your Honor, I recently filed a notice of supplemental authority, and that was Lamb v. Univision Communications. That was a 3rd DCA case. Your Honor, it was just decided on October 13th. However, there's still time for that to be withdrawn or issued a new opinion on. And just to make the court aware, that case actually certifies conflict with Gundell, which is a main case that we cited in our brief and our argument in the lower court. And that case just references the burden upon the defendant who is filing the motion for the anti-SLAPP or motion to dismiss for the anti-SLAPP or motion for summary judgment. In that case, Your Honor, the Univision strictly filed a motion to dismiss. In this case, we filed a motion to dismiss, or in the alternative, a motion for summary judgment. Your Honor, the lower court found that Ms. Talmadge did not set a prima facie claim for the application of the anti-SLAPP suit. Your Honor,
this court is more persuaded by the 3rd DCA's analysis of the plain language of the statute and whether it provides a burden shifting provision. Does that affect your argument at all as to whether Ms. Talmadge should have prevailed on the motion to dismiss?
No, ma'am, it doesn't. Our motion was actually filed in the lower court as a motion to dismiss, or the alternative, a motion for summary judgment. I do agree that the statute states that you can file a motion to dismiss and there is nothing else requiring any affidavits or anything of that nature. And the following sentence refers to the motion for summary judgment. And with the motion for summary judgment, you can file affidavits and attachments and other information for the court to consider. However, Your Honor, I do believe that this anti-SLAPP statute is an immunity statute, very similar to the stand your ground statute. And the procedure that has been decided in the stand your ground statutes are that when a defendant makes a motion to dismiss they have to establish a prima facie claim that the statute does apply. And I do believe that same procedure would apply in the case of an anti-SLAPP statute.
But the third DCA, do you agree the third DCA disagrees with it? That's the two-step process that Judge Sasso was inferring in her comments to you, that it's not a prima facie, then the burden shifts to, in your case, your opponent. It basically, as I understand, the third DCA says you just treat this as a motion to dismiss, how we analyze rulings on motion to dismiss without the burden shifting.
Your Honor, I do.
Which would seem not to be as helpful to your position, frankly, which was kind of good that you gave us notice of it, because it wasn't, I don't think it was overly helpful to your side. I don't think it's fatal, but.
No, sir. And had we just filed a motion to dismiss, I do believe that if this court agreed with the third DCA's analysis, that would affect our case. However, we didn't file just a motion to dismiss. We did a motion for summary judgment as well, or in the alternative. And further, Your Honor, since the statute allows for a motion to dismiss or a motion for summary judgment or both in the alternative, and the court to give the intent that the legislature intended for this statute when they enacted it, the trial courts can deem a motion to dismiss as a motion for summary judgment. So I do believe that can be overcome. And I do believe in the summary judgment side of it, that my client or the defendant who's filing the motion would have to argue that there are no genuine issues of material facts, which in this case, there isn't. The facts are the facts. We've agreed to the facts. Ms. Talmadge wrote an opinion letter. It was published in the opinion section, in the editorial section.
Can I ask you about, excuse me, one aspect of the letter?
Yes.
I'm sure you're aware of the United States Supreme Court case indicating that even when the facts that the opinion is based on is included in the letter, when those are false statements of fact or misrepresented facts, that might give rise to a defamation claim. And so in particular, I'm referring to the portion of the letter that states that Connor penned a letter. The explanation, of course, is that, well, the article says he was, I think, tabbed with soliciting the money, so therefore he would have been the person writing the letter. Why would that not create an issue of the fact for the jury to consider whether or not that specific fact was either misrepresented or inaccurate based on the article that was cited?
Your Honor, the letter has to be viewed, and it's a subjective test. It's the view of the person that's writing that and how they interpreted the information that they.
The letter says it's a shakedown. How would you interpret that? Well, actually, I don't really care how you would interpret it. A reasonable person would interpret that, if untrue, is certainly a defamatory statement. You're accusing him of a crime. You're accusing him of extortion, and then you send it out as a mail out, and you insinuate that, well, not your client insinuates that that this is coming from the newspaper, when in fact it wasn't coming from the newspaper. All she did was repeat what she had said in her own letter. I mean, I don't understand why that isn't sufficient for the trial court to deny that motion.
Your Honor, the trial court was required to read the article in its entirety and take it.
And I've read the article in its entirety, and reasonable people would read that article in entirety. You've accused this guy of a crime.
Well, Your Honor, first off, Mr. Connor admitted in his complaint that there were critics that were discontented with his actions, and the article that Ms. Talmadge even cited to refers to pay for play. And the fact of the matter is that in other states, yes, it is a crime. However, it's not a crime here in Florida. But she didn't state that he had committed a crime. And Your Honor, also, there's a substantial truth doctrine where a statement doesn't have to be perfectly accurate if the gist and the sting of the statement is true. And here, this entire article was in reference to Connor being.
Yeah, but you're looking at how ultimately a jury would interpret this, and the trial court was looking at this from the perspective of a motion to dismiss and a motion for summary judgment.
Yes, Your Honor, and since we filed the alternative as motion for summary judgment, and since there was no genuine issue of material fact.
Well, I don't know that there isn't a substantial issue of material fact.
Well, Your Honor, the trial court was required to go through the steps to find out or to determine as a matter of law whether the statements were actually defamatory.
Well, how do you know that he didn't do that? Or I mean, if your client had written, Connor made a request of the vendor that does business with the county to make contributions, okay, he's made a request, but a shakedown, as Judge Cohen has indicated, that certainly has a nefarious tone to it. I mean, you're shaking down somebody because that's quasi, that's a kind of a euphemism, I guess, for an extortion here, isn't it? Or at least that it raises an issue of fact from a summary judgment standpoint, and whether this was actually a malicious statement, and a jury should then determine it. And that's why the judge denied. I mean, when the judge denies the motion for summary judgment, he or she doesn't have to go into great detail as to this is what I did to reach the decision. I mean, the judge did go to some extent in this case, but it's your burden to show us that somehow there's no issue of fact, material fact here.
Yes,
right?
Your Honor. And yes, Your Honor. And had the court reviewed the article in its totality.
Well, how do you know he didn't do that? I mean, I guess that's the question. How do you know he didn't do that?
Well, Your Honor,
he obviously spent time, wrote a lengthy order. So, I mean, it's a 2-page, I mean, the attachment's a 2 or 3 page thing. So how do you know the judge? In fact, he recited it in his order.
Yes, Your Honor. However, the trial court only took one statement. And again, the substantial truth doctrine would relate back to any statement in there that may have been considered or not been perfectly accurate. But the whole gist of the article is that Connor has issues and he shouldn't be reelected. And
well, wait a minute. It's one thing to say that that he bullies women. It's another thing entirely to say that he's shaking people down. I mean, you can't take the statements, he's a bully, and say, well, everything else that we say after that, oh, that's okay because we really believe we could show that he's a bully. That's what you're arguing to us. You're arguing that because he might be a bully, that everything else we say, we get a walk on.
Well, Your Honor, since that article was based off of her opinion and her interpretation of the articles that she read.
No, shaking somebody down isn't an opinion. Shaking someone down is an assertion of fact.
And Your Honor, I guess it would come down to what the defendant or Ms. Talmadge's interpretation of shaking someone down would be. Is that a crime? No. Mr. Connor actually contacted vendors for the county and solicited contributions to a penny sales tax PAC, which he was participating with. And he was the one that was dubbed to raise the money for that PAC. So, Your Honor, taking the article in its totality.
I think that's what Judge Cohen and I are suggesting is, okay, if your client wrote a letter saying he was tasked with contacting these vendors and asking for contributions so that they could use the money for whatever purposes the government needed in Lake County, okay, that's one thing. But to say I'm shaking them down is basically certainly a suggestion that if you don't do this, there will be adverse consequences to you, vendors who work with us, who rely on business with Lake County, if you don't do that. And that certainly sounds like that sounds certainly a fact issue at that point, doesn't it? I mean, the fact that your client says, well, I didn't really mean it, then that's, I guess the jury could decide whether she really meant that or not, or whether she was being actually malicious in calling him an extortionist or
Your Honor, the article that she referenced actually discussed the fact that this is borderline criminal, and shaking down somebody could be borderline criminal. And Your Honor, it is this objective test. It is what the person who wrote the article interpreted from the information that they had. And here, Ms. Talmadge wrote her opinion based on the information that she had, and that's how she interpreted. Your Honor, I request to keep the remaining time for rebuttal.
Well, let me ask this. Your opposing counsel suggests that our review of this order that you have appealed is under the certiorari review standard as opposed to just a plenary appeal. Is that significant to you, or do you disagree with your opposing counsel?
I disagree, Your Honor, because all of the claims relating to Ms. Talmadge have been disposed of. Had they not been disposed of and the case was still ongoing, then it would have been a certiorari appeal. However, in this case, all claims against Ms. Talmadge have been disposed of, therefore, we're at a regular plenary appeal.
It's a non-final order, isn't it? And if we reverse the granting of the motion to dismiss the defamation claim, it doesn't lose its character as a non-final order, does it?
If at this present time, it is a final order because all the claims have been dismissed. Now, if the court grants the appeal filed by Mr. Connor in reference to the notice issue, then we would go back to the court and we would start all over. But as of right now, the case is final for Ms. Talmadge. I would ask to reserve the remaining time for rebuttal.
Okay, 9:25. All right, Ms. Maddox, whenever you're ready, go ahead.
Ms. Maddox, why don't you start with whether this should be a review under a cert standard or de novo?
You need to unmute yourself.
Yeah, you need to unmute. You don't have to.
Sorry. May it please the court, my name is Marie Maddox, counsel for Mr. Connor. We believe that it is a certiorari standard, and the reason is we have looked at a number of cases that have looked at these issues, and they all have considered it to be on certiorari review. So I believe.
Have you seen a case where we're in a similar procedural posture where a party has been fully dismissed from the case, such that if she does not appeal this issue now, she will not have the opportunity to appeal the issue and still treated it as a non-final order?
No, ma'am, I have not. And what I have seen, though, is on the 770.01 and 770.02 issue, that's come up for certiorari review, and the courts have found that that's appropriate in that context.
Mm-hmm.
So, no, Your Honor, I have not.
Okay. Would you agree that there's no further judicial labor as to Ms. Talmadge in this case?
Well, that's an issue that I'm not sure about. Because it is unclear from the judge's last order as to whether she is still in this lawsuit. It doesn't appear that she is, but she could be based upon the last order. And so
what about the last order creates that impression that she might be?
The last order says it was denying citizens speaking out and other, there was an order denying motion for judgment on the pleadings brought by citizens speaking out and Citizens for Better Government. And it was unclear to us as to whether we could add her back in when we did an amended complaint. The court allowed us to amend, and it was unclear as to whether we could bring her back in light of his prior ruling. So there's still an issue in my mind about whether we could bring her back in. And so the court has left open an amendment. The trial judge has put everything on hold pending this court's ruling on these issues. So everything's kind of been put on hold at this point, but it is unclear to me as to whether we can bring her back in. So there are a number of other publications, and one of our claims is the conspiracy. And one of the arguments that's not been addressed by Ms. Hargrove, by the appellant, is whether the mailer, because there's a distinct difference between the opinion letter and the mailer. The opinion letter was attached as Exhibit A. The mailer was attached as Exhibit B. And our claims were not just against Ms. Talmadge based on the opinion letter. It also extended to the mailer. And let me spend just a minute on the mailer issue and how that issue was never addressed by the trial court until because the court had dismissed Ms. Talmadge from the lawsuit. So we filed a motion for reconsideration, and because the mailer had never been addressed.
Yeah, but all the mailer really did was to effectively copy the opinion letter. And I recognize that it used the banner of the newspaper. It made it look like this was coming from the newspaper as opposed to Ms. Talmadge. The Lake County politics at its finest. But I mean, other than that, substantively, were they not the same?
They were similar, not identical. But there's a different analysis, Your Honor, and this gets into the appeal that we brought on the mailer. There's a different analysis, I believe, under 770.01 and 770.02 as to whether someone who sends out a mailer would fall into the media defendant or into the auspices of 770.01 and 760.
For purposes of pre-suit.
Exactly.
Right.
Exactly. And so what we were alleging and have alleged is that Ms. Talmadge not only did she publish her opinion, what so-called opinion letter, but she also, that same day, the mailer went out, and it was substantially based on the same information that she had included in her opinion letter, but it had a broader.
Doesn't the complaint though just say that Talmadge maliciously published the letter, but that then the false statements were then republished only with her knowledge, though by other defendants. So, and then in the civil conspiracy count again, no specific allegation that Talmadge published the mailer, only that it was done with her knowledge. So in terms of whether she would be responsible under 770 for publication of that mailer, where is that allegation in the complaint?
Your Honor, we believe that we had sufficiently set forth that all defendants had participated in this conspiracy to including Ms. Talmadge, and that would be contained in paragraphs 28 through 34, talking about the publication of both the opinion letter and the subsequent mailer in paragraphs 28 through 34. And what we had alleged is that all defendants, including Talmadge, were accused of publishing and disseminating the defamatory materials, and count 3 incorporates all of the prior paragraphs. So if we have not sufficiently stated it, then I would request leave to amend to come back and show what her involvement was.
Was that leave requested in the lower court?
Yes, it was. And that is still pending, as a matter of fact.
And okay, sorry, because that was going to be my next question, is because that was not included in your initial, the cross appeal, arguments on cross appeal, that there should be leave to amend on that issue.
No, and let me just go back and correct what I just said. We have asked for leave to amend generally. I have not asked for leave to amend specifically on this issue. But it's within the court's discretion as to whether we have, and there are multiple cases that we've cited about leave to amend on the malice issue if we have not sufficiently set malice and set forth malice, which I believe that we have, but that the court can remand back for us to flesh out those issues better. But I believe that we have on the mailer issue. And
if that is not an issue that was presented to us, whether trial court erred in granting a motion to dismiss without leave to amend on the mailer issue, how would that be appropriate for us to include in either an opinion or remand instructions?
To remand to allow us to amend, I believe that's within the broad discretion of the court to do it. But the problem is that they didn't address the issue below. And that's one of our arguments, is that they had essentially waived it. They just as counsel has focused today on the opinion letter, they did not focus on the mailer below. So the problem is that by not addressing the issue, by the appellant not addressing the issue below, then we did not fully brief that issue because of the fact that they were focused on the opinion letter and not on the mailer. So that's one of our points that we brought up on appeal, is that not allowing us to, or not fully, the judge never analyzed the mailer, never went through to look at the pleadings for as to whether our pleadings were sufficient on the mailer. Never, so that issue has never been flushed out at the trial court. So, and we have raised that issue on appeal to say, look, you added it in when we did our motion for reconsideration on the mailer issue, then the court only added another one sentence and said essentially that the claims for the mailer would be resolved exactly like on the notice issue, would be resolved exactly like the opinion letter. So it's never been fleshed out from a factual standpoint. So, and they never raised the issue below. So we're kind of shooting in the dark on the mailer, and that's what we have raised repeatedly in our brief, is to say, let us go back on the mailer issue. At least that issue needs to go back. But I do, my answer, the short answer is the court can send it back down and let the court consider, the trial court consider the issue of the mailer, just like the court considered the issue of the opinion letter. So
if we affirm on your cross appeal, I mean, well, let me first, as Ms. Talmadge sits right now, the case is over to her. Is that right, below?
it is.
Okay.
Well,
Go ahead.
I'm not exactly sure about that, but I would say 99%. Yes, sir. I'd have to go back and read the last order from the judge, but I think
the 2 counts that were asserted against her, that they've been dismissed with prejudice, and you don't like the ruling, and you're asking that our court recede from our earlier opinions that you cite.
yes, sir.
Right. So if that doesn't happen, then let me kind of shift a little bit as to the issue of attorney fees here. I mean, I understand the anti-SLAPP statute, prevailing party is attorney fees, gets award of attorney fees here and there. But I guess my question is, the argument that kind of was fleshed out during your opponent's oral argument was that maybe there's an issue of fact as to malice and it would be sent back. So denial of the motion to dismiss, motion for summary judgment, was not error. It would then go back to the trial court, right, to address that?
Yes, sir.
Let the jury decide that issue at some point?
Yes, sir.
So, I mean, at present then, but that can't happen now because the case is over to Ms. Talmadge, right?
Correct.
It wouldn't be, there's nothing to do anymore. So what I'm trying to get around to is, it says you have to be the prevailing party. How do you get an award of attorney fees on the anti-SLAPP if the case goes back and there's nothing further to go forward?
How would we get an award?
For example, somebody's up here on a non-final appeal about venue. And let's say it's in a contractual scenario with a contract that awards attorney fees. If we send it back, we don't say that the party that won the venue appeal gets an award of attorney fees. We say, okay, it's conditioned upon you prevailing at the end of the case, right?
Right.
But you're not going to prevail at the end of the case, because if we don't reverse on your cross appeal, the case is over and you're not the prevailing party in general on the case.
That would be accurate.
So do you believe you would still be entitled to attorney fees?
No, sir, I don't.
Okay, fair enough.
Yes,
That cuts down a lot of my other questions.
Yes, sir.
Go ahead.
Okay, and then let's talk about the cross appeal, okay?
Go ahead.
And I'm not being disrespectful to the court at all in terms of my argument about what happened in the plant food case. But the court did not analyze the statutes together to harmonize 770.01 and 770.02. And when you look at the mountain of cases, and when I say mountain, I'm talking about 8 or so cases that have looked at these issues, both before the plant food case and after it, because the Comins case, I believe, does not really even apply in this case because that's a blogger, okay? And I can accept that if you've got a blog, that it would be covered under and it was actually him in the Comins case. It was actually the blogger who was making the comments themselves. So Comins, I think, put to the side. But you've got what happened in the plant food case is that this court expanded that to say that someone who could have sent a publication, or a publication happened to be published, a document happened to be published, that person becomes a media defendant. And I think that based upon the Ross versus Gore case that was decided by the Florida Supreme Court in 1950, if you take that and even look at the changes of the statute that occurred, the last one I think was in 1976, that if you look progressively at what happened with social media and things like that, the courts are still, even just recently in the Missouri case, even just recently are saying that it can't be somebody who is just sending a publication in to be published with the news media. So
would you agree though that media defendant is a product of case law, and that specific term is not found in the statute?
I would, and as a matter of fact, one of the cases, I think it may have been the Missouri or the Trujillo case, that actually addressed that, and that the term media defendant came from the Ross versus Gore case.
And those subsequent cases are dealing more with the medium rather than the individual, right? Whether simply sending in a letter to a newspaper provides, the necessary protection, or entitles the person to the protection.
The Bridges versus Williamson case, the second DCA, 1984, was in fact someone who sent in a newspaper article. And what the court found there is that that does not convert someone into being.
And in that case, wasn't that article not published?
Your Honor, to tell you the truth, I'm not sure whether it was not published or not, but I don't remember that. I know that it was a newspaper article that was sent in, and that made, in my opinion, the Bridges case indistinguishable from this case. And that because, if you look back, and the Missouri case and the Trujillo are the ones that I think have gone into the greatest detail about looking back at what the legislative history was. Why do we have this to begin with? And they're looking at the dissemination of false information and how newspaper and the news press has the immediate ability to correct it. Someone like Ms. Talmadge, who sends in an article, does not have the ability to immediately correct this. And if you look at the Trujillo, and in Trujillo, there was a false dissemination of facts. And what the court said, by definition, all news media disseminates information, but it is a syllogism to conclude that all those who disseminate information automatically qualify as news media. And so looking at what the intent was of the statute when it was originally enacted by the legislature, and looking back to see at who it was entitled to protect, you can't ignore the harmony between 760.01 or 770.01 and 770.02. And a number of cases have talked about that. And the problem with the plant food case is that that was not ever discussed. How you can go back and you can do a retraction. She cannot go back and do a retraction. Ms. Talmadge, sent this publication in to the media. They published it. She is not able to go back and do a retraction. So 770.02, if you accept the argument by the defendant in this case, then nobody could send an article in. Everybody would become a news media defendant. You could publish an opinion letter, you could publish this, but 770.02 would be meaningless. And so that's the problem with the plant food case, is that there was not any analysis at all to go and look to see what the interchange was and why you even had 770.02. And that was discussed in great detail in some of the cases that we've cited, and why you even have 770.02. But looking at the Missouri case, Missouri second DCA 2019, and what the court did, and by the way, the court in virtually all of the cases that we have cited have gone back to the Ross versus Gore case and said, even though the statute has changed a little, the Ross versus Gore applies. And what the Missouri court said is that Florida courts use the term media defendant and non-media defendant to separate third parties who are not engaged in the dissemination of news information through the news and broadcast media from those who are so engaged. And the court then goes through and says that media defendants that publish news quickly can also issue retractions and corrections quickly as provided for in section 770.02. So if you look at and harmonize both of them together, as the courts in Florida have done over the years, and to harmonize 01 and 02, then it is clear that the plant food case, by not doing that, not looking at what the intent was, looking back, and the Missouri case goes through the legislative intent, according to Ross, and they're citing Ross, is to relieve newspapers and periodicals of punitive damages and libel and slander cases, as well as to afford newspapers and periodicals an opportunity in every case to make a full and fair retraction. And that's why 02 is so important, is that you have the opportunity, the news media, just as these cases, Missouri, Trujillo, and a number of the other cases have said that there is no ability to do a retraction if you're not a news media defendant.
How is that established? I mean, it certainly the paper would be the one printing the retraction, but the statute all allows for a full and fair correction, an apology, or retraction in the case of a newspaper. Why does the 770.02 fail if, for example, Ms. Talmadge, given notice, caused an apology to be issued in the paper, or a full and fair? In other words, where does the plain language specify that it must be the publication, the news, the media defendant, as the case law has interpreted it?
I think I understand what you're asking.
Yes.
That she can't. She has no control over whether the newspaper will print a retraction or not. So when you're,
she certainly doesn't have control, but now we're adding a lot of layers on to what the statute actually says, right? But it just says if a full and fair correction, apology, or retraction is published, then it's only actual damages.
But that, I think, heightens the point that I'm trying to make. She does not have any control over what the retraction is, or her correction, or an apology. That's why the news media, the broadcast media, has been identified by the courts in Florida as being responsible and being the only parties that would be covered under 770.01. Here, we have no ability, and there's no ability that she has, and that's the issue. It's not whether the newspaper has the ability to retract it. The question is whether she has the ability, and she has none.
So struggling to see how that's consistent with the plain language of 770.01. Before any civil action is brought for publication, it doesn't say, and then it says in a newspaper, it doesn't say before a civil action is brought against a publication, a broadcast, a newspaper, or periodical. There's several other ways the legislature could have worded that statute to accomplish that goal, and it might have been inconsistent with the intent, but aren't we instructed by the Supreme Court most recently to look at the plain language of the statute, yes, rather than what we believe the legislature intended?
Yes, Your Honor, but the problem with that is ignoring 02. You're looking only at 01. And so when you look at—
And that goes back to my question of how is it truly inconsistent? How does 770.02 truly fail based on the plain language? It's just, does it go back to your argument about control?
If you only, yes, ma'am, it does. If you only focused on 01, then you may be absolutely right. But you can't ignore, and I'm trying to find the case that talked about this interplay between 770.02 and 770.01.
I think it was the second DCA case that you mentioned. I think I understand the argument.
Yes, and so because of that interplay, and what the court said is you have to harmonize them. You have to harmonize, they go hand in hand, I think were the actual words that the court used. They go hand in hand. So you can't take 01 as the court did, this court did in the plant food case, and just look at 01. You have to look at what her ability would have been to correct. And that's why the news media has been singularly identified rather than non-media defendants. And there are a host of cases that have been decided by not only Florida courts, and by the way, I did want to mention the Laney case. It's been relied upon by the defendant, and the Laney case has been disapproved by Florida courts, by at least 3 Florida courts, Bridges and Davies being 2 of those cases. So the only other case that the defendant relies on is a case that has been disapproved and was decided by the Southern District, I believe. But if the court looks at, I see that my time is almost expired, but the Trujillo case, which held at a public relations firm, which issued a libelous press release, was not itself a media defendant, even though the press release was published by a newspaper. The Zelinka case, that was a Florida 4th DCA case. Same, Gifford, an advertising firm, was not a media defendant entitled to notice. We've cited the Della Donna case, the Davies case. And so if you look at the Tobin, the Bridges versus Williamson, all of those cases have said that you have to look at the media defendant based upon Ross from the Florida Supreme Court. So looking at all of those cases, you have an aberration from that in the Plant Foods case that was decided by this court. And, you know, the issue when I was preparing for the oral argument, I said, you know, this court, I don't think can, and I'm pretty sure you can't reverse a prior decision. But I would request that the court recede from that decision, or at least ask for an in-bank review and to address this issue. Or alternatively, and this is not something that I addressed in the brief, but what distinguishes, I think, the Plant Food case from this case, and I'm not sure whether the argument was ever made about the harmony between and looking at taking 01 and 02 hand in hand, and that was not done by the Plant Food case. So I don't even think that you have to recede from that opinion if the court would harmonize those two to see that it truly does cover media defendants, and that was the intent of the legislature, and go back and look at Ross and see what the cases have been that have been decided. We've cited a lot of them. I think that there are a couple more that have been decided since Ross to hold that notice would never apply under circumstances where you've got a private person sending a letter in to a newspaper and asking that the newspaper publish it. Thank you.
Okay, thank you, counsel. All right, Ms. Hargrove, you have 9 minutes, 25 seconds to use as you deem necessary.
Yes, Your Honor. Ms. Maddox advised that the mailers were not addressed in the lower court in the argument. Your Honor, the mailers were addressed in our motion and in argument. And Your Honor, I did find that I had transposed numbers from the transcript in my brief. The first discussion in reference to the mailers was on page 23, lines 1 through 3. And that's the transcript from the October 16th, 2020 hearing. Your Honor, my brief, I had put in page 32 instead of 23.
How does the policy of, the pre-suit notice, the purpose of that is to allow an opportunity for an apology or retraction. How does that fit with the position of your client who A, sends a letter in to the newspaper, and then B, pretending that it's the newspaper that's sending it out, sends out a mailer? How does the policy of that apply to your client?
Well, and Your Honor, the mailer that Connor attached as an exhibit was sent out by Citizens Speaking Out Committee. And the
Let's talk about the letter then.
Okay, so the letter.
But of course, the allegation is that there's a conspiracy with all these groups, and your client was part of that conspiracy. But if you want to just talk about the letter, I'd like you to deal with the philosophic issue.
Yes, Your Honor. So even submitting a letter to a newspaper in the editorial section opinion, people can do that. And that was a letter that the Daily Commercial had the opportunity to either refuse to
They're not a
publish,
party.
go ahead and publish it.
They're not a party. I want to deal with your client.
Yes, Your Honor. So if 770.02, as Ms. Maddox has said, doesn't congeal, I guess, with 770.01 in this case, it absolutely does, because Ms. Talmadge, if in fact she found that, you know, she did need to make an apology, or there was an error or whatever, she could actually submit another opinion letter to the editorial section.
Which they don't have to publish.
Right, correct. And then alternatively, she could take out an advertisement. She could pay to have an advertisement published. And that's not something that's against law either. Or excuse me, that is not going to be denied. And alternatively, since Maddox has claimed that Ms. Talmadge had something to do with the mailer, which there's nothing tying Ms. Talmadge to the mailer other than the fact that the mailer used wording from Ms. Talmadge's opinion letter from the Daily Commercial. Ms. Talmadge could have sent out mailers to individuals.
But isn't there record evidence that all these folks were working together?
No, Your Honor, there's not. There's just a plain conclusory claim that is not supported by any specific facts whatsoever. It just claims that Ms. Talmadge worked with these individuals, and in reality, in our motion to dismiss and motion for summary judgment in the trial court, Ms. Talmadge attached her affidavit stating that she did not know or have anything to do with Citizens Speaking Out Committee prior to the lawsuit. She did not know them, they did not know her. So just conclusory statements saying that Ms. Talmadge conspired with these individuals, it's just untrue, and it's not specific, and it doesn't state a cause that can be a claim for which can be stated.
So you think she becomes a media defendant because she can pay for a retraction? I mean, couldn't that would make everybody a media defendant, wouldn't it?
Your Honor, I think that the fact is that 770.01 doesn't apply to just media defendants, just as you stated, or the 5th DCA stated in the Coleman's v. Van Voorhees case, is that the language does not necessarily mean that only media defendants are entitled to pre-suit notice under 770.01. And in fact, you know, many of the courts, as Ms. Maddox has referred to, have referred back to the Ross v. Gore case that was decided in 1950. However, 770.01 was later amended and included additional language. And Your Honor, from 1950 until 2021, we're talking 71 years, a lot has changed. Computers have changed, even newspapers have changed. The majority of news is now online. So it's much easier for people to interact with newspapers, the media, or other publications, blogs, or anything of that nature to get information out. And that is part of free speech. And here, Ms. Talmadge had her opinion letter. She wrote it, the Daily Commercial published it. The Daily Commercial didn't have to publish it. So in fact, that letter was from the Daily Commercial. And as on the mailers, they refer to the Daily Commercial as where they got the information. And that is in fact where they got the information, just as Ms. Maddox in her complaint stated that the Daily Commercial issued an editorial stating that Ms. Talmadge's opinion letter was not necessarily the Daily Commercial's opinion. And they cite that editorial opinion letter as coming from the Daily Commercial. The same rules apply. Your Honor.
Well, let's go back, talk a little bit about the cert versus, final order. Counsel cited a number of cases that have talked about these anti-SLAPP suits and said that these are reviewed by cert. What's your best case for the contrary position?
Your Honor, if you give me just 1 second, Your Honor, all of those cases that were done by cert were all because the cases were still pending in the lower court. And Your Honor, as I
I'm
stated
sorry,
in
what-
my,
is that the name of the case that you're citing for your proposition?
no, Your Honor, it,
I asked you, what's the best case that you have cited for that contrary to those cases? I understand your attempt at distinguishing them. Do you have any case that you cite for for your proposition?
yes, Your Honor, Godwin v. State, 593 Southern 2nd 211 is a Florida Supreme Court case decided in 1992. And it states an issue is moot when the controversy has been so fully resolved that a judicial determination can have no actual effect. So, Your Honor.
But your argument on the mootness has been attorney's fees. And we're not really talking mootness here. We're talking standard of review.
I
I'm
think the
sorry.
answer is there is no case, right?
Well, actually, there is.
Really?
And well, I believe there is. The mootness does not destroy an appellate court's jurisdiction when the question is raised.
Forget mootness. I mean, basically is the standard of review. Every case that we've apparently seen or cited, it's reviewed under cert, and which is significant vis-a-vis how we analyze the issues regarding that you've raised here. But let me ask this. If the judge had just entered this as one order instead of writing two separate simultaneously entered orders, just entered one order saying denying your motion but dismissing with prejudice for lack of the pre-suit notice, would it still be cert? Would it be a plenary review of the non-final order that was?
I believe it would still be plenary appeal, and that's based off of Cookston v. Office of Public Defender 204 Southern 3rd 480, and that's decided by the 5th DCA in 2016. There, actually, the appellant did a writ of mandamus. However,
That was an issue about mootness, though, wasn't it?
yes, sir, but I think it's all intertwined because since, based on the rules of the appellate court, since the case was completed, there was nothing else left to do. That's what the plenary appeal is for. If the case had not been dismissed entirely, then it would be certiorari review
Okay.
based on the
All right.
appellate.
Anybody have any other questions?
No.
No. All right. All right, counsel. Thank you both for your arguments this morning. We'll take this under advisement and we'll stand adjourned. Have a good day.